Good morning, everyone. Welcome and thank you for joining us today for Penny Wise and Pound Foolish, Estate Planning for Real Estate Owners. This 30-minute webinar will consist of an educational presentation and discussion hosted by Karen E. Kennedy, President and Founder of NAS Investment Solutions and National Asset Services. She is joined by two expert panelists, Shelly, Paialii, partner at Squar, Milner, Peterson, Miranda, and Williamson, and Xochitl Cortez, attorney at Miranda, Bubman, and Amias. If you have any questions for the panelists, please submit them by using the Q&A feature on Zoom. A quick disclaimer we need to cover before we begin. NAS Investment Solutions, LLC is not a tax, legal, or financial advisor, and our hosting of today's event is not with the purpose of acting in any of those capacities. Also, while our guest speakers are very well versed in their respective areas of practice, and today's event should be very informative, please understand the information that will be shared with us today is not being shared to be intended to be personal advice. Neither Miranda, Bubman, and Amias LLP nor its respective employees or agents is providing legal or tax advice. No attorney-client relationship is being created through the participation in this presentation. Neither Squar, Milner, Peterson, Miranda, and Williamson LP, nor its respective employees, or agents is providing tax advice. No accountant-client relationship is being created through the participation in this presentation. All information being presented is for informational purposes only. The information provided is primarily for those located in California. You should determine what laws are specific to your state. Every situation is different, and you should always seek the advice and consultation of your own independent tax, legal, and financial advisors before taking any action. And with that, I will hand this over to Karen and our panelists. Karen, you're on mute. We can't hear you yet.
Unmute. It's
All
hard
right,
to keep me
thank you.
quiet. Thank you, Roxanne. Thank you all for joining us. Also, a little housekeeping. If we don't get to questions that you've posed when you registered, know that we will come back to you individually and respond. We're trying to keep this as general to apply to as many people as possible so everybody gets the most out of it, as you can imagine. So, with that, I think that the place we should probably start is with you, Xochitl, as the attorney on the call. Enough with the disclaimers, but if you could explain in layman's terms what the basic documents are that somebody should be considering when setting up an estate planning to maximize the benefit for their real estate investments.
No, definitely. Thank you, Karen. So when I think of an estate plan, we usually think of 4 different documents. So it's usually a will, a trust, a power of attorney, and a power of attorney for medical decisions, or what's also called an advanced healthcare directive. So a will is essentially a document that sets forth what your desires are when you pass away in terms of distributing assets. The issues that arise with a will is still subject to probate. Probate is a process whereby you have to submit the document to court, and the court essentially takes over the administration of your estate, okay? If you put a trust in your will saying, you know, I wanted to go to my kids, but I wanted to be held in trust until they turn 40, then the court will retain jurisdiction of your estate until that trust is terminated. All documents that are filed in these proceedings are considered public and not private, so anyone can go to the court and look these things up. In terms of a trust, so the trust is similar to a will. It's a document that sets forth, you know, what provisions you want to occur when you pass away, how you want your assets distributed. But unlike a will, a trust is a private document. It's never filed with the court unless there's actual litigation or disputes that arise with the trust. There are 2 types of trust, generally speaking. There's a revocable living trust, which is what most people think of in terms of estate planning. You can change this type of trust at any point during your lifetime, provided that you have capacity, okay? The other type of trust is an irrevocable trust. This is usually for gifting purposes, for estate tax purposes. The assets that you gift into this trust are considered outside of your estate for estate and gift tax. And in order to get that beneficial treatment, you must give up all control. So this trust in general is regarded as something that you cannot change. Okay, so once you sign it and set it, you need to forget it. You don't get to touch it.
Can you have both, Sochi? Can you have a revocable and a non-revocable?
Yes. So the revocable trust is simply everything that you want to keep control of during your life. So many people think, oh, there might be tax benefits or limited liability associated with a revocable living trust, but it's not. You need to treat it as essentially a change in name. Everything still gets put on your personal income tax. You have full control of your assets. Your creditors can come after everything in that trust. Let's say you've accumulated a substantial wealth, and
which is the one that creditors can come after you've gone?
A revocable living trust. Okay. So an irrevocable trust gives you some protection because those assets are considered outside of your control. Okay. You cannot touch them. Someone else needs to be the trustee of that trust. And whoever your beneficiary is in that trust is essentially the person who, quote, owns those assets. Okay. The next item is a power of attorney, usually for financial purposes. So this allows your trustee, your executor, someone that you trust with your financial decisions to step into your shoes. So let's say you become incapacitated and you're sitting in a coma and you need someone to sign life insurance premium checks or to make payments from your bank account that's in your individual name, but your power of attorney can do that. And the last document is your advanced healthcare directive or power of attorney for medical decisions. So your agent for your financial decisions does not need to be, and usually is not, the person who you want to make your medical decisions. So your advanced healthcare directive sets forth, you know, if you're in a coma or you're in a life-threatening situation where you cannot make your own decisions, this is the person or persons you'd like to make those decisions for you, and it gives them instructions as to whether you'd like artificial nutrition, you know, testing, transfusions, all of those specifics. So those are really the core documents in an estate plan.
Okay. Lots to remember. Okay.
It's a lot, but we'll kind of touch base on the various ones a little bit as we continue.
Okay. So I think that the best way, from what I've been able to, and what struck me that as we were updating our own family trust, is that there's and I see this all the time at the office, is that people have all the best intentions in the world when they set up their estate planning. Their intent is not to create animosity or ambiguity that will survive them within their families, etc., but rather to set forth what they would have done were they to still be alive and, you know, and walk on the earth. And then they pass, and then the documents don't work. So I'd like to talk about red flags that Shelly and you and I have seen over the course of our careers. And things that could have been anticipated but weren't. So I'm thinking that the first thing is to talk about what if somebody passes without having taken any steps towards planning. They own real estate, they own the house that they're in for sure, I mean, I would think. And maybe they've got investments, or maybe all they have are investments and they're, you know, in an assisted living or whatever the case might be. But they die without taking the steps for planning. That is such a nightmare. Shelly, you want to talk about that first from as a CPA?
Well, I think actually that's the bigger nightmare is the legal side of that, because your estate then has to be probated because presumably it's over, what, $60,000, Sochi? Is that what?
In California, it's $150,000. But in other states, it's a different number. So you need to make sure you check at your state. But this includes everything from your, clothing, furniture, jewelry. So if everything you own is over $150,000, which for most people they've triggered a probate.
And probate is the way the government gets to dip right in because they take money from your estate, correct?
It's not that they take money from your estate. It's you're required to now file a probate in court. And if you die without anything, we're saying no will, then what happens is your assets are now distributed in accordance with the state statutes. So if your statute in your state says, it goes equally to all of your children, whether they are, blended, it's a blended family, or whether you're estranged from your child or didn't know you had that child, a child can come in and say, I'm an heir and I'm entitled to an equal share of the estate.
And if some of your kids or grandchildren or whatever are minors, everything gets distributed as the state statute as applicable.
Prescribes.
And I think it gets tied up for quite some time too, so that you can't access the assets until the court says it can be distributed, which could be a long time.
So in California, it can take anywhere from 2 to 4 years to probate an estate. That's even with a will. And during that entire time, usually you need an attorney to assist you. And oftentimes there's statutes that allow the attorney to take a percentage of the estate regardless of how hard they work for you. So that's usually one of the downsides.
Is that a nice way of saying even if they do very little, they get to take?
Right.
Yes.
Okay, that's what I thought I was hearing without it being actually said. Okay. All right. Okay, so let's see. I got to put on my eyes so I can see what I'm saying here. So now you look at what you own, and now you're going to make an estate plan. What are the steps that people should take? Where do you even start?
So it would start really with taking an inventory of what you have, because the decisions you make in terms of your estate planning really depend on the types of assets that you have. So let's say your estate is predominantly real estate. That means it's not a liquid asset, right? You can't convert it into cash that easily. So what do you do if you have debts? How are those debts going to be paid? So that's when you start thinking, well, do we need life insurance to give the estate some liquidity? Or is your real estate held in an entity? Is it held in an LLC? Is it held in a limited partnership? And do those agreements require that when you pass away, you sell your share? A lot of people don't realize that in these entity documents that they sign, there's restrictions on your ability to transfer your ownership, right, where your partners get the right to buy you out before you can give away your shares to your children or your spouse. So
right, and sometimes
look at everything.
Right. Sometimes that restriction is a covenant within the operating agreement of the people who have invested. And sometimes more as well, on top of that, there are lender restrictions that fall into, that's what we deal with all the time. The operating agreements are supposed to be in concert and work hand in glove with the loan documents. But sometimes that isn't quite the case. There's a lot of gray in there.
Correct.
So you mentioned one of the things that somebody asked in one of the questions that came in, and that is the way that you hold title, and how is that best held as you think about these things. Who would like to weigh in on that, puppy?
So from
I think I'm sorry. Go ahead.
It's an LLC, and Shelly, I think you can opine as to the accounting standpoint.
the county standpoint?
Accounting.
Accounting standpoint.
Oh, county. Yes. So the LLC is actually the easiest to work with. You definitely do not want to hold your real estate assets in a corporation, because in a corporation, you either, if it's a C Corp, you have a double tax whenever you take anything out. And if you have a capital gain on the sale of real estate, it doesn't come through to you as a capital gain, because corporations don't have capital gains rates. And when you take anything out of there, there's no capital gain rate. So a C Corp is not good. And if you have an S Corp, if you want to take the real estate out of there, you also have to mark it up to fair market value to distribute it. So in many cases, your investors are doing 1031 exchanges and they have a very low basis. So if something is going to be distributed out, it's going to have a huge built-in gain that would have to be realized in order to get the asset out of the corporation. So an LLC is definitely the best way to hold the real estate. And then the LLC interest that they own, or it could be, a DST, or they could be holding it, the single member LLC or a DST. And those assets need to be incorporated into their estate plan. So they have to be transferred to the name of their trust once they set it up.
So I know that many of the investors, the 2,600 people that we've worked with, are in SPE, Special Purpose Entity LLCs, right? And they were TICs. Many of our clients were TICs back in the day. That is out of favor now. So now lenders are looking at DSTs. But those entities, in some cases, have been part of a group that refinanced, and they rolled up into an LLC, but they maintained their entity as at that, and their ownership interest at the LLC level of whatever their TIC was when back in the day, right? To make it, and that is the best way to hold it. Is that, am I?
Well, that's the best in their single purpose entity is the best way. However, once you have another issue, once the lender requires them to roll up into an overall LLC.
Right.
Because if they want to do an exchange again later on, if the property is going to be sold, either the entire property has to be exchanged, or they're not going to be able to do an exchange, because you cannot exchange an interest in an LLC. So even though they have their own LLC, what that LLC owns is an interest in another LLC now, and that is specifically excluded from the exchange rules.
Which is why most people who are our clients have heard me and my team say over and over again that a roll-up into an overall LLC for a new loan is their last bite of the 1031 apple. They cannot and should not assume they're going to exchange coming out of it. So
exactly. One other issue I've seen with some of the investors that have participated in these roll-ups is that they have said to us that they don't want to participate in that. So they're just going to continue to report their interest as a rental and not as part of the rolled up LLC. That cannot be done. Once it has been rolled up into an LLC, an overall one, you must report it as an interest in an LLC and report your K1. And if you report a rental on your own, in addition, you're going to be reporting double, because you have to report the K1. It's being reported to the government that way. So it's no longer a choice.
Oh, so many wonderful things happen.
Yes.
So let's talk for a moment about the way that, now people, let's say they've got kids and they say, okay, my kids, they're in different fields. They don't know about real estate. Use me as I'm the me. Okay. So I know about real estate, but my kids don't know about real estate. So I'm trying to understand what's the best way to allow my estate, right? Because I can't get out of these investments. I'm part of groups of people, and let's say that it can transfer. But because what we've seen is that parents think their kids are going to get along, and they always got along. And yeah, because they're sitting at the table with their parents. They may not, they may have issues that go way back to kindergarten when somebody ate, took their favorite toy or something. I mean, you just never know. And we have seen families come undone over what seem to be small things to us, but that there's a whole history behind it. So how do you counsel people? Because each of you have had the same experience, I'm sure, as we have. How do you counsel people to deal with that potential?
So this comes up very often, and it's one of the biggest challenges, because parents often think, oh, my kids are always going to get along, and don't acknowledge that when they're gone, all the little cracks in the sibling relationship become huge crevices. So oftentimes we don't recommend that you have multiple siblings acting at the same time. Choose one or choose none. And if you absolutely must have siblings act together, then you need to have a tiebreaker. You need to have someone that's neutral, third party, that can come in and make a decision when the siblings cannot get along. But more importantly, it's the option that you don't have to choose family to act as your trustee. You don't have to choose your children to act as your trustee. When you're thinking about your trust, you should really choose the person that is most knowledgeable about your assets and the type of assets that you hold. That may be your accountant, that may be a best friend, that may be a fellow partner in a business. And if you're concerned about that person perhaps abusing their relationship, then put this person, an accountant or business partner, in conjunction with a family member. Usually a committee works often if you have significant concerns, but you should always tailor your trustee based on what your assets are and who will be able to manage those assets in the manner that you want them to be managed. Because your kids may decide, mom and dad are gone, let's sell everything. Or let's reinvest in something that maybe you didn't think was advisable. So if you really want to control those decisions, you should have someone that understands what your planning is and what your assets are.
If I could just interject, I think also if you can find a person that you trust that's able to do that in conjunction with one of the kids, or you trust to do alone, that's better than using a corporate trustee like a bank. Correct. Because the bank does not care what your assets are or what your wishes were or what your kids may want. They're going to do what they deem is best, and they're going to move on in their own direction. And once they're in, it's very difficult to get them out.
Yes, I would say banks and corporate fiduciaries, companies that just act as trustees, should be your very last resort, because they are very stringent in their standards. They are not flexible. They're not going to care about what your children or your family needs if it's not spelled out in the document, because all they care about is, well, am I going to be sued? What's my liability? I have to follow the instrument to a T, and I have to account for everything. And they're also going to bill you a far greater fee, trustee fee, than a family member or a trusted professional in your life.
Can you set that? You can set those fees within your trust if you set up a trust, can you not?
Yes, but for corporate fiduciaries, they will not accept to act as your trustee unless you accept their standard fee schedule.
At whatever time that is, which is after you're gone, and they change their fees, right?
Correct. They will just refuse to act if they're not comfortable with the trust or the fees.
Okay. Let's talk for just a moment about what happens if you've, using the failed to fund your trust, right? Things. Can you guys, but each of you, touch on that for a moment?
So that's one of the biggest mistakes. You go to the attorney, you set up all these documents, your trust, your pour over will, your power of attorney, etc., and then you never change title to your assets and to the name of the trust. Congratulations. It's almost as if you did no planning, and now everything that still remains in your name is now probated. So
Well,
the
that's
trust
what I remember when I did it with you, Sochi. It took you almost a year on some of these because some of the lenders didn't want to make the change. Yeah.
Yes, you have to be very careful. If you have a loan on a property, most of your loans will have what's called a due on sale clause, where if you transfer ownership, it's considered a default and they call your loan. 90% of the lenders will consider a transfer of a property into a revocable trust an exempt transfer. But you still have to communicate that to the bank and make sure that they understand what's happening so that there's no effect on your loan.
And once you transfer the assets, you need to file the forms with the assessor's office showing that there is an exempt transfer of ownership. So it's just a change of name, that the effective ownership is still 100% the same, so it's not reassessed at that point. And you have to do that within, I believe, 90 days. If you don't do it, then they can reassess the property for one. And once you fight it out with the assessor's office, which could take a long time and get it fixed, they still can charge you a 10% penalty for not having filed that form within the 90 days. Even if there's no reassessment, they can charge you 10% on the value as a penalty. So it's important to report any change in ownership immediately, especially if it's exempt from reassessment.
So speaking of values, Shelly, can you talk for a moment about when somebody dies and there's a step up? We use the term all the time, but as it relates to capital gains, a step up in basis. Can you explain in layman's terms what that means and how it works?
Sure. So when somebody dies, their estate gets valued on the date of death for estate tax purposes and when it's being distributed. And the step up is the assets reset their cost basis to the date of death value. So if somebody had done a 1031 exchanges over and over again and they had essentially no basis left in their property, and then they died and the property was worth $2 million when they died, the new cost basis on that asset is $2 million. So if you were to gift something to your heirs or your grandchildren or children while you're still alive, a gift goes at cost basis or fair market value, whichever is less. So if you were to gift something, say today while you're still alive, and you had done several 1031 exchanges into this last property, and you had $100 of basis, but it's worth $2 million, when you do a gift on that date, you use up $2 million of your lifetime gifting and estate tax exemption. Right now, we're all allowed about $11.5 million to gift through gifts or an estate without tax, gift tax. So you use up $2 million of your exemption, but the cost basis goes at the cost basis because it's lower. So you're using up $2 million of exemption on your gift tax, but your beneficiaries are getting it at $100 basis. So they're not escaping the capital gains tax. That's a big mistake that people do when they're doing estate planning, because they're gifting very low basis assets. You should be trying to gift stuff that has a high basis if possible, so that you don't use up your exemption and still pass on a capital gain to somebody. When you die with the asset and the basis resets to the date of death value of $2 million, your heirs can sell it then if they want to, and there's no capital gain because the asset basis has reset on the date of death. So gifts before date of death keep the same low cost basis. Gifts through the estate or inheritance through the estate resets and avoids the capital gains that have built up over the years.
And if you're in a community property state like California, Shelly, where the property was purchased by a husband and wife, mm-hmm. and then one dies, is the step up in basis is applied to only 50% of the value of the property at the time of their passing, or is it, how does that work?
If it's community property, 100% of the basis is stepped up. But I think if it's joint tenants, only the half right, Sochi, that of the person who
Correct.
died. So it's important to make sure if it's a community property estate and you're holding it husband and wife, that you're holding it with the proper title,
Right.
so that both halves will step up.
And
Right.
that also comes into the estate planning, because if you decide to separate your trust into separate portions, when let's say the husband dies first and all his assets get lost into a trust, if you don't structure that trust appropriately, you may not get the second step up when the wife dies. So you want to make sure that when you're planning, that you plan tax-wise to get both step ups if it's really a lot of real estate or things like that. You don't want to lose that second step up.
How often should people review their trust? Because it's like everything, nothing should ever be put on a shelf, right? And say, okay, I'm done, I did it. How often should somebody go back and say, okay, let's revisit my trust?
So there's no set rule as to how many years, but essentially anytime there's a change in the tax laws with regard to gift and estate tax, you should revisit your estate. And anytime there's a major change in your family situation, you've had another child, you've had grandchildren, maybe something has happened where the capacity of a child or your spouse is in question. Those are all times when you need to come in and revisit, are the terms of my trust what is most appropriate in light of the changes in my life?
Okay, well, I've been pinged. We're being pinged by Roxanne. Out of respect for all of you, we set this at 30 minutes and it flew by as we knew that it would. There were a lot of great questions that came in. So I know that when I came up with this topic, that it was something that people needed to hear and think about. So now we've given you just snippets and tidbits of things to consider. But really appreciate your time. And for those questions that were submitted either before, during, or if you send them in after, we'll respond to you. I promise that. Roxanne, I'm sending it back to you, and Shelly and Sochi, thank you.
Thank you.
Thank you.
Thank you, Karen, Sochi, and Shelly. And thank you to the viewers for submitting such awesome questions. A recording of this webinar will be available on our website in a few days. That's nasinvestmentsolutions.com. And you will receive a brief survey via email after the webinar. And we hope you take a minute to let us know your thoughts. Thank you.